i te whare e tū nei, e te whenua e kaputoki waho, ko te ahu mai rangi, e te moana o te whanganui ata, e te mana whenua o te atiawa tēnā koutou. Ko te mea tūtahi kangi atu ki a rātou ko mene ki te pō, ko whiturangi tia, o ki rātuna mate, kei runga i a tātou katoa. Moi mai o te atu. Ko rātou tērā, te hunga mate ki te hunga mate, ko tātou tēnei, e no hora nei, mauri ora ki a tātou katoa. Ai ngā mane, ngā reo, ngā rauranga tira. Nau mai, hara mai. Hara mai ki te kura tātai tui o te whare wana o te herenga waka. E te kaipōrero o te pō nei, e te marae kura, e te manu ariki whakataka pō kai, te kai whakawā tumuaki o Aotearoa a tēnā koe. Nau mai, hara mai. E ngā kai whakawā, tēnā koutou, e te whānau Cooke, tēnei te mihi ki a koutou. Nau mai, hara mai. Te kahurangi, Sean, tēnā koe, tēnei te mihi ki a koe. Ka koutou katoa ngā kaimahi, ngā tauira, o tēnei kura tātai ture, ngā memo o te hunga roia o Aotearoa, tēnā koutou, Kua he mihi ko te tēnei, mihi mai o hātia koutou, tēnā koutou, tēnā rā tātou katoa. Kia ora koutou. My name is Helen Jones, I'm a member of the faculty here, and it's my pleasure to just begin by acknowledging those who have passed on, by acknowledging the space that we're in, and beginning the welcome of you all and our speaker for this evening. And with that, I'll hand over to Dean.
E nā mana, e nā waka, e nā reo, ki nā tini karanga, no nā hou e whā. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Kei nā maunga, kei nā moana, kei nā awa, kei nā mana e tū, mai ne tēnā koutou katoa. Tēnei mātou e noho iho, ne kei nā pai a Maui e mihi atu, ne kia koutou. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Tulofa lava, malo elele, nisam bulavanaka, kia orana. Distinguished guests, colleagues and friends all, welcome. Welcome to this, our Faculty of Law at Te Herenga Waka, Victoria University, Wellington. It is my pleasure to follow my colleague, Dr. Carwyn Jones, to open proceedings this evening and to introduce the Right Honourable Dame Helen Winkelmann, Te Tumu Whakawā o Aotearoa, Chief Justice of New Zealand, who is delivering this year's Robin Cooke Lecture. I acknowledge all here who have been greeted, including all members of the Judiciary, and I wish to repeat the welcome of my colleague. My name is Mark Hickford, and it has been my privilege to serve as Pro Vice Chancellor and Dean of Law here at Te Herenga Waka, Victoria University, Wellington, since May 2015. This lecture represents a significant occasion for all of us. Established in 2001 in honour of Lord Cooke of Thorndon, the lecture is an end-of-year flagship event for our diverse legal and university communities. I wish to make special mention, therefore, of the Cooke family, specifically the Honourable Justice Cooke, Diana Marsh, Philip Cooke, Alice Cooke, and Isabella or Bella Cooke, who I understand is visiting us from the United States. Thank you for being here. Lady Cooke cannot be with us today, but I also wish to acknowledge her continuing unflagging support, for which I and the faculty are very grateful. Thank you. We all know that this year, 2020, brought with it extraordinary challenges and considerable uncertainties. I wish to express my personal gratitude to all colleagues at the faculty, academics and professional staff, as well as those members of the wider legal profession who participate in our teaching, events and seminars. The work this year has been undoubtedly hard and exhausting. All colleagues have done an incredible job during what has been an extremely tumultuous time. Everyone at our faculty has worked assiduously in an unprecedented effort to keep our community safe, deliver our academic mission, and contribute to the fight against COVID-19. We have reinvented how we teach, learn and work in a rapidly evolving environment, and through it all, we have built new capabilities in the way we operate. And I wish to express thanks to all of our wonderful students. For many of you, jobs were lost, routines disrupted, access to study space was a challenge, and mental space and energy were taken up by worries about COVID-19 and its possible impacts on the health of our broader communities. All of you make this community of legal research and teaching such a success. For our standing, our reputation, we must thank the indefatigable, steadfast devotion and energy of academic and professional members of the faculty and the fine qualities of all our students and alumni. I salute you all. Without your energy, your tireless efforts, your commitment to quality, these achievements would not be possible. Our faculty colleagues care deeply for the service they undertake and the contributions they make, and they are ambitious for this university, for the city and this nation. Thank you. I must also make important mention of a colleague here this evening who will be ushering in the 50th anniversary of his place here at the faculty, Professor David McLaughlin, as of the 1st of January 1971, joined this faculty, and so we are coming to that moment. So thank you very much, David. It's fitting probably to acknowledge, given the topic of the themes this evening, the continuities of half a century of service. And to that end also, I acknowledge the fine efforts that are recorded in this alumni magazine that have been distributed here this evening. Chief Justice Winkelmann's lecture today is entitled Picking Up the Thread, the Common Law, Continuity and Change in Challenging Times. It is apt that we hear an address on the common law, on continuity and change, picking up the thread, or perhaps threads. 30 years ago, in 1990, at the 9th Commonwealth Conference, Law Conference, Sir Robin Cooke, as he then was, reflected on what he called the dynamics of the common law, remarking cautiously that the achievements of the common law are often instinctively and greatly overrated by those who have been nurtured in it. And yet, he said, of its very nature, it has a vitality of its own and cannot help moving. And elsewhere, the common law is nothing if not malleable. By dynamism, he said he meant of its very nature, the common law is an instrument of principled justice, capable of fresh life and vigour. Secondly, courts are often willing to use this instrument to its full potential. My colleague, Carwyn Jones, acknowledged those who have passed and those we have said farewell to. And we cannot single out any particular names, of course, but I did want to at least reflect, because it seems to resonate, that earlier this year, in a period of tumult and turbulence for all, the Irish poet Evan Boland passed away. Her wonderful piece in memory of the Irish suffragettes of 1918 reminded us that our own futures, whatever they might be, will be the past for others. We owe it to our ancestors and to those who succeed us to remember. To remember, she said, those who struggled and prevailed, all those who had the faith that voices can be raised, can be heard. All those who saw their hopes become the law. All those who woke in a new state of being and becoming, flowering from a fading empire. Justice no longer blind, inequity set aside, and freedom redefined. That was the voice of a poet who passed this April of 2020. In closing, I wish each and every one of you the very best of blessings for the holiday season, and may the new year in 2020 bring you and your cherished ones every good fortune and success. I express my gratitude again on behalf of the Faculty of Law for your ongoing invaluable support. There will be no questions in this session. It'll be a lecture, but we will then, after some closing remarks and celebratory singing, proceed to refreshments. I now ask that you join me in welcoming the Chief Justice of New Zealand, the Right Honourable Dame Helen Winkelmann. Thank you.
Professor Hickford, tēnā koe. Kei ngā tini whetū o te rangi nei, tēnā koutou katoa. I begin this evening by acknowledging the presence of Lord Cooke's whānau, his sons Philip and Francis, and their whānau, tēnā koutou koto, koutou matua kua whetū rangitia. I also acknowledge Dame Shana Lice, my judicial colleagues from all of the courts of Aotearoa, and the many stars in our distinguished audience tonight. Tēnā koutou, kia ora mai, tātou katoa. You humble me by your attendance. I'm grateful for the invitation to deliver this year's Robin Cooke lecture. Well, that is, I'm grateful now. I wasn't about 2 weeks ago. Honouring, as it does, one of New Zealand's foremost legal minds. Lord Cooke was an outstanding jurist and scholar. And as Professor Hickford said, a frequent theme of his extrajudicial writing was the common law, how it works, how it has developed, and its potential for change. He was an early debunker of the notion that judges were only required to objectively apply law, which had been sitting there since time immemorial, just waiting for us to discover it. He wrote about change that was underway. He described and he approved New Zealand's movement away from unquestioning adherence to English law. He encouraged judges to develop and lawyers to advocate for law appropriate to circumstances of New Zealand. He suggested that they should, freed from lockstep with Britain, look to other countries, to Australia, Canada, the United States, and to international instruments for ideas as to how that law could develop. By the 1980s, New Zealand law had set off down a distinctive path, partially in response to litigation in connection with the Treaty of Waitangi, but also in response to other aspects of New Zealand society, its institutions of power, economy, environment, and its media. A distinctive jurisprudence developed in relation to judicial review, the tortious duty of care, and in the area of defamation, with Lord Cooke playing a key role in these developments. Now, in 2020, we are at a point in time when the calls for change to our courts and our justice system are loud. I'm going to speak to two topics tonight. I'm first going to describe my own conception of the common law method, and in so doing, describe a narrative of continuity and change since Lord Cooke's era. The underlying principles of the common law are the threads I refer to in the title to this address. I will explain how, through continuity of process and principle, the common law method provides the stability and cohesion that underpins our society. But this method also enables change, ensuring that the law and its processes remain connected to the community it serves. That ability to change lies at the heart of the common law method, and as I explain, at the heart of judicial legitimacy. I will also describe situations in which the common law method has failed, identifying common threads that characterise that failure. I then address one of the most pressing challenges for our society and for the common law method, repairing the criminal justice system. Although many criminal justice issues lie beyond the power of the judiciary, The courts are part of that system, and so the judiciary must play its part in addressing this challenge. To do otherwise would be a failure of the common law method. Finally, I outline how it is that the common law has the content and methodology to assist us as we frame our response to this challenge and the lessons we should carry forward from the past as we do so. So what is the common law method? Well, when I refer to the common law method, I mean more than just the method judges use when they decide cases by reference to precedents or by interpreting and applying statute law. This is one aspect of the common law method, but it also includes the work judges do in applying the values and associated concepts that shape our law and which run deeper than any individual precedent. I also include the basic procedural and operating model used by courts in Aotearoa, New Zealand, and other common law jurisdictions. And so I'm going to say something now, I hope. So this is a diagram to explain for those who aren't familiar with the art of weaving or the making of fabric. So when I refer to the common law, when I refer to this metaphor, I chose the metaphor of threads because fabric metaphors have always seemed to me particularly apposite to the law. Looking back, I have noticed a tendency in my own judgments to use them. It's easy to think of the law as a fabric, and the way it is created is something like weaving. The underlying values and concepts that run through the law are the warp, those strong binding threads. And that warp provides its basic shape and gives it its coherence and stability. The individual cases and the judgments that result are the weft, providing the detail and texture of the law. So that's the diagram there, showing the warp and the weft. Perhaps these fabric metaphors resonate with me due to my own whakapapa. My family has been engaged in the textile trade in various parts of Europe and more recently in New Zealand for at least the last 200 years. Talk of fabric and thread was a constant in my childhood home. And I'm also not alone in any case in thinking about the law in this way. It's a metaphor often used, perhaps most famously in Wilmington and the Director of Public Prosecutions, where Viscount Sankey spoke of the presumption of innocence as the golden thread running through the common law. A fabric metaphor is especially apt for our context here in Aotearoa, New Zealand. The art of weaving is a Māori taonga and is full of symbolism and meaning. The photo you see behind me is of our new ceremonial judicial robes. So these were designed to reflect the two founding cultures of New Zealand. The garment is based on the traditional black gown worn by barristers and judges to reflect our common law heritage. But the fabric from which it is constructed incorporates elements that reflect our unique heritage and traditions. Kauri cones and leaves are the underlining design embedded in the black weave of the fabric. And the image on the right, is it on your right? Yes, it's on your right, is a close-up of the braid on the edge of the robe. This is a potama pattern used on tukutuku panels and in other Māori art forms and symbolises whakapapa as well as the progressive levels of learning and intellectual achievement. To some it represents the steps the god Tane ascended in climbing to the highest of the heavens in his quest for knowledge. There he retrieved 3 baskets of knowledge, Te Keti Tuatea, the basket of light, Te Keti Tuori, the basket of darkness, and Te Keti Aronui, the basket of pursuit. The imagery of these 3 woven keti has been captured on the shoulder of the judicial gown, an apt parallel to the different bodies of knowledge that judges must draw upon in their task: knowledge of precedent, knowledge of their societies, and knowledge of the direction in which the law is or should develop. The repository of the common law and of the common law method is case law, which is the first basket of knowledge. The doctrine of precedent is one of the defining characteristics of the common law. Lord Cooke highlighted the drift away from reliance upon English cases that was discernible just around about the 1960s in New Zealand. But even when I was at law school in the 1980s, the cases I was taught were almost exclusively English. This drift away then came very late in our history. From the first days of the nation created by the Treaty of Waitangi, there was an opportunity and a need for the law to adapt to meet the very special circumstances of this nation. New Zealand, after all, had an established population when English law arrived, a people who had in place a developed set of customs and usages, and a very different economy and social structure. While it's true that the early judges inherited English statutes, they were instructed in the very statute that brought those acts into force in New Zealand that they should apply those acts of Parliament so far as applicable to the circumstances of the colony. It would be a fair account to say that, allowing for a few notable exceptions on which I will touch later, little accommodation for New Zealand's circumstances was made prior to the 1970s. And for as long as the common law of England remained the dominant source of precedent in New Zealand, the law was constrained by the values and needs of English society and could not and would not change to meet the needs of the society it served. So, the genesis of the New Zealand common law. The genesis of the trend away from this approach to English authority can be traced to the end of World War II, when New Zealand began to chart its own path in trade and international relations. After World War II, there was an explosion of creativity in New Zealand in literature, in art, in music composition, and in the study of New Zealand's history. This reflected a new interest in understanding, but also in developing, a distinctive New Zealand identity. This creativity was not, however, initially matched in the common law. Even so, a growing body of statute law began to reduce the relevance of English authority, a trend accelerated by the United Kingdom's entry into the European Common Market in the 1970s. It was perhaps then perversely statute law and the common law's application and interpretation of statute that was the most powerful force in developing a distinctive New Zealand common law. The creation of the Waitangi Tribunal in 1975 and the expansion of its jurisdiction in the 1980s highlighted the uniqueness of the issues that needed to be addressed in this country. This led to the re-emergence in public discourse of contested views as to the meaning of the treaty. The inclusion in the State-Owned Enterprises Act of Section 9 and the effect given by the Court of Appeal to the words "nothing in this Act shall permit the Crown to act in a manner inconsistent with the principles of Treaty of Waitangi" added impetus and urgency to treaty claims. Important also, with the benefit of hindsight, was the decision of Justice Chilwell in the High Court in the Huakina Development Trust case. Well, at least it's important to all of us. With the benefit of hindsight, it was apparent to many people at the time, particularly those counsel who argued the case, that it was a very important decision, because in that case, Justice Chilwell said that the Treaty of Waitangi is part of the fabric of New Zealand society, so that where possible, statutes should be interpreted consistently with its requirements. And that was a 1987 case. The increased reference to New Zealand's own jurisprudence and as authority, the abolition of appeals to the Privy Council, the creation of a New Zealand Supreme Court has further realised the aspirations of a law appropriate to New Zealand's circumstances. Now lawyers and judges look to the decisions of New Zealand courts, and student casebooks are overwhelmingly made up of New Zealand case law. When we look further afield as lawyers and judges, we look in a discerning way to the best ideas in other jurisdictions. Adopting a comparative approach, judges are happy to pick up the best and most appropriate solutions for New Zealand from the case law of many nations. So, that's case law, but case law, even binding precedent, is not a code which provides all the answers. That is because the common law is made up of values that are big enough and flexible enough to allow the law to change to meet the needs of place, people, and times. I refer to these values and concepts as the warp of the law, and because they are big and flexible ideas, they must be applied carefully to the facts of each case. In the 18th century, Lord Mansfield identified the underlying values of the common law as morality, honest dealing and good faith. Today we would agree at least for the values of honest dealing and good faith, but perhaps reject as too subjective and undetailed a concept, morality, to be useful in this context. We would add in new values and concepts such as fairness and its procedural sister, natural justice, reasonableness, proportionality, and restraining the abuse of power. These values are captured in the legal concepts throughout the law. They are the source of the doctrines of good faith, undue influence, unconscionable conduct, duties of care, and the law of misrepresentation, to name but a few. Deciding a case under the common law method entails the judge bringing to bear the point of decision, their own knowledge and experience of life to decide, for example, what is fair and reasonable and what is an abuse of power. It entails the judge having sufficient knowledge of the case before them to apply those concepts in accordance with those underlying values. For this reason, judges need information as to the context in which they are making their decision, the context of the individual before them, and the context of the community from which the individual comes. Lord Cooke recognised the centrality of the judge's knowledge and experience when he expressed the view that an understanding impartiality is the most important judicial quality, and he acknowledged that true impartiality does not come easily or naturally, it has to be striven for. This method ensures that the law has within it the potential to change with a changing society, and in so doing, continue to reflect the fundamental values of that society. This acknowledgement of the nature of the judicial function, which entails an abandonment of the declaratory theory of law, has implications for the administration of justice. Our concept of the ideal judge, and even of ideal judicial behaviour, has changed. At a collective level, it means that a judiciary is ideally drawn from diverse parts of society and has diverse experiences in life, including diverse experiences of working within the law. This is important to the quality of the law the courts produce, as the path judges have walked through life and through the law shapes how it can develop and how it will develop. But that's not enough. More than life and legal experience is needed to judge in a diverse and changing society. And for that reason, judges are no longer expected to withdraw from society on their appointment. They're encouraged to stay engaged with their communities. And judges are expected to continue to learn about their society throughout their judicial career. It's for this reason that in the last 20 years, in most common law countries, increasingly sophisticated educational institutions have developed, charged with offering educational programs to judges. In New Zealand, we have our own Te Kura Kaiwhakawā, the Institute of Judicial Studies. This view of how the common law method operates means that it also matters who the lawyers are. For the law to develop, the right arguments have to be made, and they have to be made by counsel. It's not the judge's job to come up with the arguments. What's required of lawyers in terms of diversity of experience and perspective is no less demanding than what is required of judges. Indeed, so profound is the human element in the law that there is an alternative account waiting to be written which plots the development of the law by reference to pivotal actors, but more on that later. So what are the common law's sources? Well, as my narrative of the development of a distinctive New Zealand law, common law suggests, statute law has increasingly influenced common law developments. It's looked to as a source of the values that can be incorporated in the law, and legitimately so, since it's the product of the democratic process. It's also looked to as a source of ideas. New Zealand statute law, and sometimes statutes from overseas, provide models of how the common law can respond in analogous situations. In 1992, President Cooke recognised that the analogy of a statute may properly influence the development of the common law. And in 1999, writing extrajudicially, Lord Bingham said that statute and common law should feed and refresh each other. In 2010, the majority of the Supreme Court noted that it has become convention in New Zealand jurisprudence for the broad purposes of relevant legislation to inform whether and to what extent a duty of care should be owed at common law. And from the earliest of times, custom has been a source of the common law. Custom is, of course, a source of the values in a society, but it can also be a source of detailed rules regulating social and economic relations. Lord Mansfield, again, famously convened juries of business people to provide evidence to him of commercial custom so that he could then weave that custom into the common law. And he did that because in the 18th century, the common law was devoid of the values, ideas, and forms of action needed to support the English economy as it transitioned from a feudal, agricultural-based economy into one based on trade and finance. Over the last 20 years in New Zealand, the role of custom in our law has come into focus. Judges are directed by numerous statutes to have regard to tikanga when deciding cases, particularly in the area of family and environmental law. Many more statutes direct that representatives of the executive and statutory bodies must have regard to tikanga in their decision-making, and the courts may be called upon at a later stage to review those decisions. Outside of statute, the common law has recognised tikanga in a variety of ways, and no doubt that evolution will continue. Tikanga has the potential to add depth of meaning to our law, reviving the communitarian values that have been obscured by the weight of precedent, while also adding new ideas and values into our law that are grounded in and come from this place. As a living and therefore changing body of customary law, great care is needed in how the common law approaches issues of tikanga. The risks some have raised that the processes of the law will damage tikanga should not be lightly put to one side. But I'm hopeful that we're starting to see both the judiciary and the profession approach this task with the care and humility it requires, beginning as we must with a desire to understand. The treaty, Te Tiriti, is another source to which judges look for the content of the law. The treaty is incorporated into New Zealand law through the Treaty of Waitangi Act, under which the Waitangi Tribunal has the task of interpreting the two language versions. But in cases raising issues of statutory interpretation, and often in judicial review proceedings, the mainstream courts are required to apply the principles of the treaty. Those principles are currently referred to in over 25 statutes, excluding those implementing treaty settlements. The nature of the principles to be applied by the courts has emerged and developed from case law. In the 1987 New Zealand Māori lands case, the Court of Appeal found that these principles include partnership, active protection, informed decision-making, redress and rangatiratanga. Since this case, the treaty principles have continued to evolve in both the courts and the Waitangi Tribunal. And for completeness, I've noted that international law is another source of the common law, and it's covered in the written paper, but because of time constraints, I won't speak to it tonight. So I've described where judges look to for the content of the law, but the common law method also depends upon process. At the heart of those processes lies the notion of a fair and public hearing, a hearing at which all parties have an equal opportunity to participate and at which the parties and public can see the processes of the court play out in a fair manner. New Zealand society is based upon the premise of the equal application of law to all, the defining characteristic of a society that is under the rule of law. In hearings before our courts, counsel argue for the equal application of the law to their clients' circumstances. The common law principle of natural justice guarantees to each party that they will be heard on matters that affect their interests. That requires in turn that each party to the litigation be able to participate as effectively as the others if they choose to do so. The requirement that justice be administered in a manner which renders it open to public scrutiny is the surest means of holding judges to these ideals. The principle that proceedings must be conducted in public is so powerfully embedded in the common law that it's not open to the parties to agree between themselves to private hearings, to the sealing of the court file, or to suppression of the judgment or names. There's also an important human element to these processes. I've already made the point that it matters who the judges are because of the contribution judges make as a collective to the content of the law, but it also matters how they act. The common law is a human system made up of face-to-face interactions. When the parties and a judge meet in the courtroom, the procedural justice applied in the hearing enables acceptance of the ultimate judgment. The judge affords dignity to the participants and the proceedings by diligently paying attention and reacting in a human way to what unfolds in the courtroom. The humanity in this process is its most essential feature. The judiciary's claim to legitimacy rests in large part upon its ability to provide equal treatment before the law and its commitment to affording all those who come before it, before the courts, the dignity of a fair hearing. The detailed processes of the court are based around the face-to-face model of justice. They are designed to support the two objectives of a fair and open hearing. The standard operating model of the New Zealand courts, however, is still that brought with the settlers from England. While most of these processes remain valuable, we do not need to carry every aspect of this model with us into our future. As we find our feet on the soil of a specific nation, we are growing in confidence to change the processes of a public hearing so that the court can best serve this time and place, reflecting our cultures and our values. So the incorporation to the common law of values and concepts from these multiplicity of sources leads to change in the law. Because of the steadying effect of precedent, the change may be incremental, but it's not inevitably so. The common law can be creative and even dynamic in responding to the needs of the society. The development of the duty of care, which imposed duties to those foreseeably harmed by a defendant's actions, was a radical development, but it was necessary to respond to the complexity of relationships in an urbanised and industrialised society. Closer to home, an example of speedy development of the law can be found in the application of the doctrine of constructive trusts to address distribution of property occurring on the breakup of de facto relationships. This development responded to the rise in the number of relationships outside of marriage and the absence of a statutory property sharing regime for the situation. Constructive trusts were used to address the resulting injustice where property was divided simply in accordance with legal title. The common law then can respond to challenge and change within a society. Through the doctrine of precedent, the common law brings stability, but it also allows the injection of new ideas and for the creation of new responses as required. So having just made the case for the common law method, I should also record that it's not infallible. It's important to acknowledge where the common law fails so that we can learn from those failures. The system of precedent is often painted as the villain of the piece when the law fails. The constant looking back to past decisions is cast as conservative, perhaps even reactionary. It's true that while judges were looking almost exclusively to English law for precedent, the development of a distinctive New Zealand common law was delayed arguably for almost 130 years. But a more careful review of these failures reveals that it is not often the method at issue, but the human element within it. When I was at law school in the 1980s, we studied a series of decisions of the House of Lords delivered at the end of the 19th century in which the power of the unions was attacked. There's a plausible account to be given that through a series of cases, Allen and Flood, Quinn and Latham, Taff Vale Railways, Lord Halsbury waged a campaign using precedent and procedure to defeat the power of the unions. The outcome in these cases was driven by the views of judges, and especially the efforts of one particularly powerful personality. These judges weighed the interests of one side of society only, those on the capital rather than labour side of the employment relationship. It's less comfortable but more important to look at missteps that took place closer to home. I've already referred to the failure of the common law to respond to the circumstances of New Zealand. The case of Wiparata and Bishop of Wellington is a well-known and good example of this. In that case, the then Supreme Court was asked to apply a section in the Native Affairs Act, which gave the court jurisdiction in relation to the persons and property of Māori, touching the title to land held under Māori custom and usage. Chief Justice Prendergast, writing for the court, declined to give effect to customary title, famously opining that a phrase in a statute cannot call what is non-existent into being. To reach that conclusion, the Chief Justice had to disapprove the unreported 1847 decision in Queen and Simons, a decision of the earlier Chief Justice Martin and Justice Chapman, which recognised the existence of native title in land as part of New Zealand law. Simons was decided in the early days of the colony by judges who would have been eyewitness observers of the extent of the customary law that existed around the time of the signing of the treaty. If the precedent of Simons had been followed, it logically would have compelled a different decision. But the Wiparata case was decided at a different time, in the aftermath of armed conflict and against a continuing background of settler pressure for land as a tradable resource. Chief Justice Prendergast was applying common law method, he did not abandon conventional reasoning processes. But as I said earlier, the human element is an inseparable part of that method. The decision reveals a perspective shaped only by the settler view of society, by their values and by their interests. The judge's failure to weigh or to be aware of critical facts about a society meant that he did not, to quote Lord Cooke, reach his decision implying an understanding impartiality, and that caused the common law method to fail. So, conclusions on the common law method to this point. From this narrative, I reached the following conclusions. First, the content of the common law is woven around values and ideas that allow the law to change, and if needed, change quickly to meet the needs of the society. The task of the judge is to apply those ideas and values to the facts of the case before them. This adds new content and shape to the concepts as over time our values change. These features of the method provide the common law and its practitioners with legitimacy. Third, the task for the judge is therefore Herculean. Judges must have experience of the diversity of their society. They must also continue to learn after appointment so that they remain knowledgeable about their society and its values. This knowledge feeds directly into the law. It's when judges fail to continue to learn, or when they allow their own values to inform the law unchallenged, that the common law method fails. So, these lessons are not of theoretical interest only, and I started thinking about them when I was thinking about how the common law method could deal with a variety of changes, demands for change and criticisms of the broader criminal justice sector. So for me the question became, how can the common law method respond to the challenges of today or the future? I'm going to focus on only the challenge of building a criminal justice system that restores and keeps communities safe and prevents reoffending by repairing the lives of offenders. Beginning in the 1980s, a series of reports have described failings of the criminal justice system, some characterising that system as broken. We're told that it harms families, particularly Māori families. It seldom prevents reoffending, but perversely creates the conditions for recidivism. We're told it harms the whānau of the offender, and in so doing continues intergenerational harm. Victims of crime don't feel safe, listened to, informed, or supported at each stage of the system. Some say they were further harmed by the justice system. We are told the criminal justice system does not meet the diverse needs of Māori, Pacific, refugee and migrant, disabled, and LGBTQ+ communities. It's constructed according to Anglo-centric ideas of law and justice, and it alienates those who engage with it. We're told the system is confusing and slow, and that delay itself is a source of harm to victims and to defendants. Many leave the court feeling that they have not been heard or that they have not understood what has happened in the courtroom. We also know that many within the prison population are themselves past victims of violence or trauma, or struggling with addiction, cognitive deficits, or mental health disorders. We have high rates of imprisonment and staggering rates of Māori imprisonment. That this is so is highlighted by the following figures. 1 in 12 New Zealand males born in 1981 had spent time in prison by the age of 35. For Māori males, the same statistic is 1 in 5. There is a perception that one of the impediments to a more enlightened criminal justice system is a punitive public sentiment which prioritises punishment over other values. However much this narrative may have taken hold in our media, we know that it does not necessarily represent the views of most New Zealanders. The recent New Zealand Crime and Victims Survey found that helping offenders not to reoffend and supporting people so they don't offend in the first place were seen as more important aims of the criminal justice system than punishing people who have committed crime. Repairing the criminal justice system is one of the most pressing challenges for our society. But it is a complex system, and the judiciary is responsible for only a part of it. Moreover, the answers do not all lie within the criminal justice system. They also lie in the areas of health, housing, employment and education. A national hui held in Rotorua in April 2019 told us the importance of understanding that the justice pipeline starts at birth. In her Shirley Smith address, the then Chief Justice Dame Shana Elias said that it is our society that creates criminals and asked us to reflect on the conditions that do so. Nevertheless, the court system is involved in the processes and circumstances that have produced the criminal justice crisis, and so the judiciary must play its part in addressing this challenge. If it does not, that would represent a failure of the common law method. In responding, the courts can look to lessons I have canvassed in the first part of this address. One such lesson is that a fair hearing requires an understanding impartiality. When so many of the defendants who appear before us have cognitive deficits or other disadvantage, the ideal of a fair hearing is in peril. The common law judge must strive to understand what is needed to ensure the defendant can participate in the hearing and what is required to rehabilitate the defendant and to restore the community. If the defendant is unable to participate in the hearing and so is unable to provide relevant information to the judge will not have the information to ensure the law is applied equally to that defendant. Moreover, and just as fundamentally, the content of the common law will lack the detail and pattern, the weft I mentioned at the outset, to respond to society's needs. Looking back at those threads of the common law, that also reminds us that the law must evolve to meet unique circumstances and challenges. We see this already happening through developing a solution-focused model of justice, characterised by support and rehabilitation for the defendant, their whānau and the victim, as well as the use of information about each defendant to facilitate their full participation in the process. In New Zealand, we have many courts operating a solution-focused model of criminal justice, and I'm going to read them all because there's a point to be made. These include the Family Violence Courts, the Youth Drug Court, the Matariki Court, the Pacifica Courts, the New Beginnings Court, the Special Circumstances Court, the Alcohol and Other Drug Treatment Court, the Sexual Violence Pilot Court, the Intervention Court, the Personal Individual Needs Court, the Criminal Procedure Mentally Impaired Persons Court, and the Young Adult List Court. These courts apply the standard law, but have been developed by judges in response to the particular needs and circumstances of the groups they serve, and they have become centres of best practice. They provide a way in which the courts can draw on the knowledge of subject matter experts, and most importantly, the community, using that knowledge in the court process to the benefit of all. The use of pilot courts such as these is a good way of testing out new operating models. But now these pilot courts have made their case that they are a better version of criminal justice. However valuable these many courts are individually, at present they serve only a tiny portion of the defendant cohort. They have not been integrated into our mainstream criminal justice system, and that fact alone risks undermining the foundational common law principle of equal access to justice. Last month, Chief District Court Judge Hemi Taumanu described the vision of a new model of criminal justice called Te Ao Marama. The vision is that the best practice established through these specialist courts will become the mainstream model for the district court. It is that the court will become a place where all people can come to seek justice, no matter their means, ability, culture or ethnicity. Properly resourced and implemented, the mainstreaming of the fundamental concepts underpinning solution-focused courts will provide judges with the information and courts with the connections to serve defendants, victims and their families and communities. It will be a criminal justice system fit to meet the diverse needs of Aotearoa New Zealand. I believe the time for this model has come, but as we work on its design, it's important we build its detailed patterns around the threads that make up the warp of the criminal justice system. First, the thread of equal access to justice. A fundamental thread of the law. This requires the movement to mainstreaming happen deliberately and with some speed, because a system under the rule of law cannot tolerate postcode justice. Secondly, although this new model makes way for the community to provide therapeutic interventions, the fundamentals of a fair trial must not be compromised by it. One of the aspects of a fair trial is the presumption of innocence. We need to take care to ensure that a guilty plea is not the price of receiving therapeutic assistance. We need to watch carefully how systemic incentives operate, lest they operate to compel a plea of guilt. Finally, although in this solution-focused model we will be making room for others to assist the defendant and to provide information to the judiciary, the common law model requires that the processes be open to scrutiny by the defendant, the victim, and the public. The values that are reflected in our criminal justice system are powerful. They go to the heart of how a society functions and how it thinks. The creation of this model of justice will be demanding of resource and of all within the criminal justice system. It is a new fabric in the law, and we must take great care with its weaving. As with the steps presented in the Potama pattern in the robes we wear, our task as we weave is to strive to greater levels of understanding of the community we serve. Because this is a human system based on human interactions, that is its greatest strength. I therefore leave you with this whakatauki. Nā oku quia tēnei kākahu I whatu, ko te rimu kei au, kei aku mokopuna a muri I hoa. It was my grandmothers who wove this fine cloak. I will work on the hem, as will my grandchildren after me. Kei ngā tini ringa whatu o te kākahu nei, kei aku rangatira, tēnā koutou, tēnā koutou, tēnā tātou katoa.
Thank you very much all. It now comes to me to simply express thanks on behalf of the gathering here this evening for a wonderful intervention by the Chief Justice in this end-of-year Cooke lecture event. She has spoken of the metaphors of warp and weft, and I couldn't help but notice as I was listening to the address that I was reminded of when there was reference to Huakina Development Trust, that sometimes the weft, the particular instance, becomes something that is left for a little while on a pathway, perhaps to be gathered up, not yet tied, not yet hemmed, but something that can be continued at a later date. And as the former Chief Justice appreciates, that case had references, as I seem to recall from the text, to a distant decision of the 1920s, I think Mullock was the name of it, about the way in which an intangible, seemingly intangible object can be invested with legal personality, can be animated, and can be a subject of duty and guardianship and protection. And of course, this particular instance was carried and conveyed in future times and gathered up by others. So the thing about the weft, so to speak, is that it can become part of the warp, or at least illuminate it. And likewise, the caution that was offered about statutes as detailed patterns themselves. Ironically, a person who often is subject to critique as a historical actor of the past, Sir John Salmond, did caution that statutes have their own trajectories and they themselves can be treated by the courts as illuminating values, and the courts might use them to catch up themselves. So there is actually a caution to be seen in statutory patterns as well. So I think what the Chief Justice has left us with this evening is full of potential, obviously, for regathering loose threads and bringing them together. So with that note, I ask that you all join with me to congratulate the Chief Justice on tonight's lecture, and I will ask you to join us all in refreshments outside the lecture theatre. Thank you.